Hello and welcome to HR Talk, where this week we're discussing suitable alternatives to redundancy. I'm joined today by Paul Mander.
Hi.
Paul is a partner and co-head of the employment department at law firm Penningtons. Recently, a case called Samsung Electronics versus Monte-D'Cruz dealt with the issue of appointing external candidates to newly created roles when there were existing employees within the organisation who were at risk of redundancy.
In the case, there were four members of management whose jobs were effectively disappearing, and they were being replaced by one management role. And the claimant applied for that role, and he was unsuccessful, and that seemed to be relatively uncontroversial. But as a second stage of this redundancy process, there were a number of other management roles that were created, and one of those roles he thought was exactly the same as his job, so he applied for it. He applied for it with one other internal applicant, and he was graded against a set of criteria which were quite nebulous. They were slightly subjective, which is usually a sort of slightly dirty word in legal parlance for a redundancy procedure. Anyway, the company thought, Samsung thought, if he didn't score 75, that was their cut-off point. If he didn't score 75, then he wouldn't get the job. Now, neither he nor the other internal applicant got the job, and they hired somebody from outside on a consultancy basis, actually. Now, he complained to the Employment Tribunal, and the Employment Tribunal thought they had a good claim. They thought that the company applied these criteria in a very subjective way, and that the job should have been given to him. And they awarded him quite a significant amount of compensation. They didn't even make any reduction for the chance that had they handled it properly, he wouldn't have got the job. So they were pretty strongly behind him. And Samsung appealed to the Employment Appeals Tribunal, which is the next stage up from the tribunal. And in that case, when the court heard that, they comprehensively overruled the tribunal. And what they effectively said is that there are two main points that come out of the case on the hearing. And one of them was the fact that they said that subjective criteria are okay, they're all right to use in a situation where you're interviewing somebody for a job. So for this alternative role, they were happy that although the criteria was slightly nebulous, that was okay. It was still a fair process. And they said that, for instance, when you're interviewing anybody for any job, there are certain elements of judgment which come into it which make it more subjective than purely objective. That I don't have an enormous amount of problem with. But the second part of it was they also thought it was okay to bring into that mix somebody from entirely outside the company. So I can sympathise with the fact that there are two internal candidates and there are relatively nebulous criteria, and it's slightly subjective when you're choosing between two people whose jobs would otherwise be redundant. But when you add somebody from outside into the mix, that changes the complexion of it somewhat.
How does this case extend employers' scope for deciding who is suitable for a vacancy when there's a redundancy situation running concurrently?
In legal terms, I think it extends it quite a lot, although, as I'll say a little bit later, I think that I'm slightly sceptical about it. I mean, previously, what we had thought, and what I'd certainly advised in the past, was that somebody who's being made redundant, you have a duty to look for any suitable alternative employment for them. And if there is a job for them, then you should be giving it to them. And the whole purpose of consultation, in one way, is to try and avoid redundancies. Now, that would really mean that if there is a suitable job for somebody who's going to be made redundant, you give it to them. You don't look elsewhere. You don't look outside the company at an entirely new potential workforce before deciding on who should have that role. So I think this case does extend it slightly in that you can be more relaxed as an employer in having an interview which is merit-based, and even if it's slightly subjective, involving people from outside the company, which is something I would not have been relaxed about before this case.
Paul, what would your advice be to an employer facing a situation similar to the one that occurred in the Samsung case? Are they safe to pick external candidates for new roles when they're also making redundancies?
Well, I think if they've already done it, and they're going to be in court about it, then this case gives a lot of solace and a lot of support for them. I would not advise that people do it, even with this case. It's employment appeal level, so it is binding on employment tribunals. But I think the mere fact that the tribunal found so heavily in favour of the claimant in this case, they had to get to the employment appeal tribunal stage before the employer won it. Now, normally, on a practical level, you don't want people to go to the tribunal. So I think I would treat this case with some caution, actually. I would still prefer that if there is a suitable role, that you consider the internal applicants for it, certainly before you involve anybody externally, if indeed you involve someone externally at all. And I think the concentration really should be on whether a role is suitable or whether it's not suitable, not whether that person is the most suitable person to do that job. There is a distinction there, because the latter really involves us looking at anybody else in the world who could be more suitable for the job. And of course, I suspect that there is somebody more suitable for all of our jobs.
Paul, thanks for joining us today.
Very welcome.
And if you want to find out more about the subjects we've been discussing today, go to People Management's website.